So good day and good bless you everyone. We are the group 5 and in this video we are going to discuss to you the Republic Act 9262 or the VAUC. But before anything else, I would like to say a few reminder. Just stay home and keep safe from COVID-19 pandemic. So, Republic Act 9262. What is the Republic Act 9262? It is an act defining the violence against women and their children, providing for protective measures for victims, prescribing penalties therefore and for other purposes. So, in this video, we will discuss to you what does this act known for, what are the purpose why this act has been enacted, and what are the penalties under Republic Act 9262. So, Republic Act 9262, this act shall be known as the Anti-Violence Against Women and Their Children's Act of 2004. So, why does this act has been enacted by the Senate and the Congress of the Philippines? It is because the state values the dignity of women and children and guarantee full respect to the human rights. And the state also recognizes the need to protect the family and the members of the family, especially the women and children, against the violence and threats to their personal safety and security. So this act shall be liberally construed to promote the protection and safety of the victims of the violence against women and their children. As used in this act, we have the term violence against women and their children. So, what do you mean by violence against women and their children? Violence against women and their children refers to any act or series of acts committed by any person against a woman who is his wife, his former wife, or etc. that may cause to physical violence, sexual violence, psychological violence, and economic abuse. So, what do you mean by physical violence, sexual violence, psychological violence, and economic abuse? When we say physical violence, these are acts that include bodily or physical harm. When we say sexual violence, these are acts which is sexual in nature committed against a woman or her child. So, when we say psychological abuse, this refers to the act that can cause or likely to cause mental or emotional suffering of the victim. And when we say economic abuse, this refers to the act that can make a woman financially dependent. So, the crime in violence against women and their children is committed through the following. Letter A, causing physical harm to woman or child. Letter B, threatening to cause the woman or child physical harm. Letter C, attempting to cause the woman or her child physical harm. Letter D, placing the woman or her child in fear or physical harm. Letter E, attempting to compel or compelling the woman or her child. Letter F, inflicting or threatening to inflict physical harm on oneself for the purpose of controlling her actions or decisions. Letter G, causing or attempting to cause the woman or her child to engage in sexual activity. Letter H, engaging in purposeful, knowing or reckless conduct. And letter I, causing mental or emotional anguish, public ridicule or humiliation to woman or her child.
So I am Jeremy O. Tagbas from BSED English 1. I am here to continue discuss to you the sections under RA 9262. So let's proceed to the section 6 penalties. The crime of violence against women and their children under section 5 hereof shall be punished according to the following rules. In A, acts falling under section 5 constituting attempted, frustrated, or consummated parricide or murder, or homicide, shall be punished in accordance with the provisions of the revised penal code. So those persons who commit VAUC shall be punished in accordance with the provisions of the revised penal code. If these acts resulted in mutilation, or if this act caused damage or resulted causing damage, it shall be punishable in accordance with the revised penal code. those constituting serious physical injuries shall have the penalty of prison mayor. So, those who commit serious physical injuries, so they have the penalty of prison mayor. Those constituting less serious physical injuries shall be punished by prison correctional. So those who commit less serious physical injuries shall be punished by prison correctional. And those constituting slight physical injuries shall be punished by arresto mayor. Acts falling under Section 5 shall be punished by imprisonment of 2 degrees lower than the prescribed penalty for the consummated crime as specified in the preceding paragraph, but shall in no case be lower than arresto mayor. So, those person who commit vowsy, their imprisonment ranging is from 1 month and 1 day to 20 years. Acts falling under Section 5 shall be punished by arresto mayor. Acts falling under Section 5 shall be punished by prison correctional. Acts falling under Section 5 shall be punished by arresto mayor. Acts falling under Section 5 shall be punished by prison mayor. Acts falling under Section 5 shall be punished by prison mayor. If the acts are committed while the woman or child is pregnant or committed in the presence of her child, the penalty to be applied shall be the maximum period of penalty prescribed in this section. So those persons who committed vowsy while the woman or child is pregnant, the penalty to be applied shall be the maximum period of penalty prescribed in this section. In addition to imprisonment, the perpetrator or the person who committed vowsy shall pay a fine in the amount of not less than 100,000 pesos but not more than 300,000 pesos. So makabayad sila not less than 100,000 pesos but not more than 300,000 pesos rather. And the person who committed vowsy undergo mandatory psychological counseling or psychiatric treatment and shall report compliance to the court. So, katong nakakumit o violence against women and their child, mo undergo sila og psychological counseling or psychiatric treatment. And kung sa manggani ang result to their counseling, they shall report compliance to the court. Section 7. Venu. So, where should cases of vowsy be filed? The regional trial court, designated as a family court, shall have original and exclusive jurisdiction over cases of violence against women and their children under this law. In the absence of such court in the place where the offense was committed, the case shall be filed in the regional trial court where the crime or any of its elements was committed at the option of the complainant. So, kung kinsa tong or those who are victim of vowsy, so makafile sila kaso dito sa regional trial court because regional trial court, they have original and exclusive jurisdiction about the cases of violence against women and their children. So, Where should case for VAUSI be filed? So, the case of VAUSI be filed is in the Regional Trial Court. Section 8, the Protection Order. So, what is protection order? A protection order is an order issued under this act for the purpose of preventing further acts of violence against a woman or her child specified in Section 5 of this act and granting other necessary relief. So, this order is for preventing further acts of violence against a woman or her child. This is a protection order for the victim of the VAUSI. The relief granted under a protection order should serve the purpose of safeguarding the victim from further harm, minimizing any disruption in the victim's daily life, and facilitating the opportunity and ability of the victim to independently regain control over her life. So, the purpose of this protection order is to safeguard the victim of the VAUSI, to minimize disruption in their daily life, or regain or facilitating the opportunity and ability of the victim to independently regain control over her life. So, as what we have known that kung kinsa tong victim sa VAUSI is their life will be messed, their life will be controlled. So, this is in order to prevent those mga acts that harm their life. So, protection order is the best used to prevent those acts. So, the provisions of the protection order shall be enforced by law enforcement agencies. So, there are three kinds of protection order. First, the protection orders that may be issued under this act are the Barangay Protection Order or the BPO. Second is the Temporary Protection Order or the TPO. And third, the Permanent Protection Order or the PPO. The protection orders that may be issued under this act shall include any, some, or all of the following reliefs. Letter A, prohibition of the respondent from threatening to commit or committing personally or through another any of the acts mentioned in Section 5 of this act. So in under the protection order, the person who committed VAUSI is prohibited from threatening to commit or committing personally or through another. They are not allowed to threaten to commit or committing acts that can harm to the victim. So, in letter B, prohibition of the respondent from harassing, annoying, telephoning, contacting, or otherwise communicating with the petitioner directly or indirectly. So, they are not the respondent or the person who commit VAUSI are not allowed from harassing, annoying, telephoning, contacting, or otherwise communicating with the petitioner or the victim. So, bawal. Dili sila gina-allowed nga mo contact pa sa victim, the VAUSI. Next is removal and exclusion of the respondent from the residence of the petitioner. petitioner, regardless of ownership of the residence, either temporarily for the purpose of protecting the petitioner or permanently where no property rights are violated. And if respondent must remove personal effects from the residence, the court shall direct a law enforcement agent to accompany the respondent to the residence, remain there until respondent has gathered his things, and escort respondent from the residence. So, another relief under this protection order is removal and exclusion of the respondent from the residence of the petitioner. So, those person who committed VAUSI, so pwede silang mo pahawa sa balay nga gipuyo sa victim. For example, if ang mag-asawa is yung bana yung commit of violence against her or her child, so pwede silang mapapahawa sa balay temporary lang. But if kung ang respondent or the commit of violence against women and her child, if they are removed personal effects from the residence, if ginasunod nila tong rules nga gi-implement aning under protection order, so the court shall direct a law enforcement agent to accompany the respondent to the residence. So, remain there until respondent has gathered his things and escort respondent from the residence. So, they will remain until ang respondent has gathered his things and escort respondent from the residence. So, next is directing the respondent to stay away from petitioner and any designated family or household member at a distance specified by the court, and to stay away from the residence, school, place of employment, or any specified place frequented by the petitioner and any designated family or household member. So those person nga commit ani nga crime, they are directing to stay away from the victim. So they are not allowed to kanang duol sa victim or any family baka sa victim or household member at a distance specified by the court, and to stay away from the residence, school, or place or asa or employment or asa na trabaho or trabaho ang victim, or any specified place nga pwedeng where the victim nga niadto or naadidto, bawal ang kanang mga kanang place nga akong i-mention. So this is the purpose for panong God kanang in this way kanang ma-prevent ang acts of violence against women or her child. Next is directing lawful possession and use by petitioner of an automobile and other essential personal effects, regardless of ownership, and directing the appropriate law enforcement officer to accompany the petitioner to the residence of the parties to ensure that the petitioner is safely restored to the possession of the automobile and other essential personal effects, or to supervise the petitioner's or respondent's removal of personal belongings. Next, granting a temporary or permanent custody of a child or children to the petitioner. So, those who commit violence against women or a child, they are granting a temporary or permanent custody of a child or children to the petitioner. So, kuanan sila o temporary or permanent custody sa ilang anak. So, next is directing the respondent to provide support to the woman and her child if entitled to legal support. So, the respondent should be provide support to the woman and or her child if entitled to legal support, even though those kanang na-commit sila o crime, they are still obliged to support the woman or her child. Notwithstanding other laws to the contrary, the court shall order an appropriate percentage of the income or salary of the respondent to be withheld regularly by the respondent's employer and for the same to be automatically remitted directly to the woman. Failure to remit and or withhold or any delay in the remittance of support to the woman and her child without justifiable cause shall render the respondent or his employer liable for indirect contempt of court. So, kung dili ang respondent or the person who commit vowsy, kung dili sila makaremit o kanang support sa ilang asawa or anak through the money, or dili sila makaremit og kwarta kanang without justifiable reason or cause, shall render the respondent or his employer liable for indirect contempt of court. So, the respondent or his employer is liable for indirect contempt of court if ever nga dili siya makaremit or any delay in the remittance of support to the woman and her child. Next is prohibition of the respondent from any use or possession of any firearm or deadly weapon and order him to surrender the same to the court for appropriate disposition by the court. So, the respondent or the person who committed vowsy is not allowed from any use or possession of any deadly weapon and order him to surrender the same to the court for appropriate disposition by the court, including revocation of license and disqualification to apply any license to use or possess a firearm. If the offender is a law enforcement agent, the court shall order the offender to surrender his firearm or any deadly weapon and shall direct the appropriate authority to investigate on the offender and take appropriate action on the matter. Next, restitution for actual damages caused by the violence inflicted, including but not limited to property damage, medical expenses, childcare expenses, and loss of income. Next, directing the DSWD or any appropriate agency to provide petitioner temporary shelter and other social services that the petitioner may need. So, if the petitioner is having needs, they will direct to the DSWD or any appropriate agency para to provide petitioner temporary shelter para ma-provide ng ilang mga kinahanglan and other social services that the petitioner may need. Next is provision of such other forms of relief as the court deems necessary to protect and provide for the safety of the petitioner and any designated family or household member, provided petitioner and any designated family or household member consents to such relief. So this protection order is also under ANI is to protect and provide for the safety of the petitioner. So, it should ang victim sa vowsy is dapat ma-providean sila o maprotektahan, as well as ang family or household member sa victim. Any of the reliefs provided under this section shall be granted even in the absence of a decree of legal separation or annulment or declaration of absolute nullity of marriage. So, even though this relief ma-provide under this section or this relief shall be granted even though the absence of a legal separation or annulment or declaration of absolute nullity of marriage. The issuance of a BPO or Barangay Protection Order for the pendency of an application for a BPO shall not preclude a petitioner from applying for or the court from granting a TPO or BPO. So, those I have mentioned are the following reliefs under protection order that issued under this act. So, what akong ipang-mention is under siya sa mga unsay kaayuhan for the victim or sa mga prohibited sa naka-commit of crime or commit of violence against women or her child. So those are the following reliefs of protection orders. So let's proceed to the section 9. Who may file petition for protection orders? A petition for protection order may be filed by any of the following. First, the offended party. Next, parents or guardians of the offended party. Next, ascendants, descendants, or collateral relatives within the fourth civil degree of affinity. Next, officers or social workers of the DSWD or social workers of local government units. Next, police officers, preferably those in charge of women and children's desk. Next, punong barangay or barangay kagawad. Next, lawyer, counselor, therapist, or healthcare provider of the petitioner. And lastly, at least 2 concerned responsible citizens of the city or municipality where the violence against women and their children occurred and who has personal knowledge of the offense committed. So it means at least 2 concerned citizens of the city or municipality kung asa nahitabo ang violence against women and their children, and those who are nakasaksi ana nga panghitaboa. So those I have mentioned are the following who may file petition for protection order. Section 10. Where to apply for a protection order? Applications for BPOs or Barangay Protection Orders shall follow the rules convened under Section 409 of the Local Government Code of 1991 and its implementing rules and regulations. So, the application for Barangay Protection Order shall follow kung unsaang rules convened under the Section of 409 of the Local Government Code of 1991 and its implementing rules and regulations. An application for a TPO or Temporary Protection Order or PPO or Permanent Protection Order may be filed in the Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court, Municipal Circuit Trial Court with territorial jurisdiction over the place of residence of the petitioner. So, the application for TPO or PPO may be filed in the following the Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court, Municipal Circuit Trial Court, with territorial jurisdiction over the place of residence of the petitioner. So, lahi ang application for PPO o lahi pod ang application sa TPO or ang PPO. Provided, however, that if a family court exists in the place of residence of the petitioner, the application shall be filed with that court.
Good morning everyone. So let's continue the section 11 of this topic. So the section 11 states on how to apply for a protection order. So the application for a protection order must be in writing, signed and verified under oath by the applicant. It may be filed as an independent action or as an incidental relief. In any civil or criminal case, the subject matter or issues thereof partakes of violence as described in this act. The section number 12 states on the enforceability of protection orders. All TPOs and PPOs issued under this act shall be enforceable anywhere in the Philippines, and a violation thereof shall be punishable with a fine ranging from 5,000 pesos to 50,000 pesos and or imprisonment as of 6 months. The section 13 state on the legal representation of petitioners for a protection order. So if the woman or her child request in the application for a protection order should order for the appointment of counsel because of lack of economic means to hire a counsel party, the court shall immediately direct the public attorney's office or the PEO to represent the petitioner in the hearing on the application. So, if the PEO determines that the application can afford to hire the service of a counsel party, it shall facilitate the legal representation of the petitioner by a counsel party. So, the lack of access to family or conjugal resources by the applicant, such as when the same are controlled by the perpetrator, shall qualify the petitioner to legal representation by the PEO. So the section number 14 states on how the barangay protection orders of the PPOs, who may issued and how. So the barangay protection orders refer to the protection order issued by the punong barangay, ordering the perpetrator to desist from committing acts under section 5. And of this act, a punong barangay who receives application for a BPO shall issue the protection order to the applicant on the date of filing after ex parte determination of the basis of the application. Section number 15 states the temporary protection orders. The temporary protection orders or the TPOs refers to the protection order issued by the court on the date of filing of the application after ex parte determination that such order should be issued. A court may grant in a TPO any, some, or all of the reliefs mentioned in this act shall be effective for 40 or 30 days.
Hello, I am Analaika Ingito and I am here to continue the Section 16 to Section 25 of the Republic Act 9262. In Section 16, Permanent Protection Orders. Permanent Protection Order or the PPO refers to the protection order issued by the court after notice and hearing. Respondent's non-appearance despite proper notice of his lack of lawyer or the non-availability of his lawyer shall not be a ground for rescheduling or postponing the hearing on the merits of the issuance of the PPO. If the respondents appear without counsel on the date of the hearing on the PPO, the court shall appoint a lawyer of the respondent and immediately proceed with the hearing. In case the respondent fails to appear despite proper notice, the court shall allow ex parte presentation of the evidence by the applicant and render the judgment on the basis of the evidence presented. The court shall allow the introduction of any history of abusive conduct of a respondent even if the same was not directed against the applicant of the person for whom the applicant is made. So it goes to show that dito sa section 16 ipanapahayag dito na kahit kailanman ay hindi na makakalapit yung, for example, yung husband, hindi na siya pwede makakalapit sa kanyang anak o sa kanyang asawa dahil it is against the law, it is a violation between the law and him. So next is we have section 17. Section 17, notice the sanction and protection order. The following statement must be printed in a bold faces type or capital letters on the protection order issued by the punong barangay or court. So now let's proceed in the violations of this order and is punishable by law. Section 18, mandatory period for acting on applications for protection orders. Failure to act of an application for a protection order within the reglementary period specified in the previous sections without justifiable cause shall render the official or the judge administratively liable. So the mandatory period for acting an application for protection orders is this mandatory period means kung saan, kailan lang yung act in the application act na mangyayari in the application for protection orders. Now, section 19, legal separation cases. In cases of legal separation where violence as specified in this act is alleged, Article 58 of the Family Code shall not apply. The court shall proceed on the main cases and other incidents of the cases as soon as possible. The hearing on any application for a protection order filed by the petitioner must be conducted within the mandatory period specified in this act. So this act, legal separation, means only that you are separated from a house but you are still married. Kung sinasabi na separated kayo tapos pwede ka nang mag-asawa, that is annulment. At iba yun sa legal separation, because legal separation has a lot of considerations to make. When you violate legal separations, cases will be bigamy, adultery, and concubinage. So in the section 20, priority for application for a protection order, ex parte and adversarial hearing to determine the basis of the application for a protection order under this act shall have priority over all other proceedings. Barangay officials and the courts shall schedule and conduct hearings on application for a protection order under this act above all other businesses, and if necessary suspend other proceedings in order to hear applications for a protection order. So in this section, the application is prioritized by the officials or the court, the barangay officials or the courts. It must have an immediate schedule and conducts hearings and application para magkaroon agad ng protection order. Now, in section 21, violation for protection orders, complaint for a violation of a BPO issued under this act must be filed directly with any municipal trial court, metropolitan trial court, or municipal circuit trial court that has territorial jurisdiction over the barangay that issued the BPO. Violation of a BPO shall be punishable by imprisonment for 30 days without prejudice to any other criminal or civil action that the offended party may file for any of the acts committed. So when for example the husband is violating the protection order, na yung lumapit siya at nang harass again or somewhat like that, doing such crime, lumapit lang siya or ganun, that is also a violation, right? So that is where violation of a BPO shall be punishable by imprisonment for 30 days. So makukulong siya ng 30 days even without the prejudice to any criminal crime or civil actions, kahit wala siyang ginawang masama. So, a judgment of violation of a BPO may be appealed according to the rules of court. During trials and upon judgment, the trial court may be motu proprio issued on a protection order as it deems necessary without need of application. So, the violation of any provision of a TPO or PPO issued under this act shall constitute contempt of court punishable under Rule 71 and of the rules of the court without prejudice to any other criminal or civil actions that the offended party may file for any of the acts committed. Now, in Section 22, applicability of the protection orders to criminal cases. So, the foregoing provisions of the protection order shall be applicable and applied issued with the criminal actions involving violence against women and their children. So, the protection order is applicable when crime happens, like for example, the father raped his daughter in a certain point, so it is a crime. So the protection order is applicable into that. Hindi dapat makakalapit or makakagawa ng kung ano man yung ama ng kanyang anak. So that is the applicability of protection order into criminal cases. Section 23. Bond to keep the peace. The court may order any person against whom the protection order is issued to give the bond to keep the peace, to present two sufficient sureties who shall undertake that such person will not commit the violence sought to be prevented. Should the respondent fail to give the bond as required, so dito kasi sa Section 23, bond to keep the peace, meron itong mga mandatory acts na kailangan gawin, but if the respondent failed to give the bond as required, he shall be detained for a period which shall in no case exceed for 6 months. So, makukulong siya or madidetain siya ng 6 months. But if he shall have been prosecuted for acts punishable under Section 5A to 5F and not exceeding 30 days. And now, let's proceed to Section 24, the prescriptive period. Acts falling under Section 5A to 5F shall prescribe 20 years. Acts falling under Section 5G to 5L shall prescribe in 10 years. Now, in Section 25, public crime. Violence against women and their children shall be considered a public offense which may be prosecuted upon the filing of a complaint by any citizen having personal knowledge of the circumstances involving the commission of the crime. This is public crime. So any person that witnesses the crime, any person that witnesses the circumstance, pwede siyang mag-complaint or pwede siyang mag-report sa krimen na iyon. So in this sections, hindi lang yung victim, it's not just the victim who can report or complain in such crime. So pwede rin yung mga nakakita or those witnesses, naka-witness na crime na ito, pwede din silang mag-report, pwede din silang mag-complaint laban dito.
So, in section 26, we can find here the battered woman syndrome. So, a victim survivor who are found by the courts to be suffering from the battered woman syndrome do not incur any criminal and civil liabilities, nor withstanding the absence of any of the elements justifying circumstances of self-defense under the revised penal code. In section 27, there is a prohibited defense. So being under the influence of alcohol, any illicit drug, or any of the mild altering substance shall not be a defense under this act. So in section 28, you can see here the custody of children. So the woman victim of violence shall be entitled to the custody and support for her child. So children below 7 years old older with a mental or physical disability shall be automatically given to the mother with the right to support unless the court finds concealing reason to order otherwise. Section 29, we can see the duties of the prosecutors and the court personnel. So what are their duties? So the court personnel or the prosecutors should observe duties when dealing with the victims under the act. So first, they should communicate the victim in a language that they can understand or the woman or her child can understand. And next, they should inform the victim of her rights, including legal remedies available and procedures. And in section 30, we can see the responsibilities of the barangay officials, wherein the barangay officials who fails to report the incident shall be liable for a fine not exceeding 10,000 pesos or whenever applicable to criminal, civil, or administrative liabilities. Section 31, we can see the healthcare provider for the abuse, including but is not limited to an attending physician, nurse, clinician, barangay health worker, the counselor who suspect abuse or has been informed by the victim of violence shall do their responsibilities in this Act, Republic Act 9262. It is not only the health provider has their responsibilities, but also the government agencies and other LGUs have their duties. So the duties of the government agencies and the LGU should establish a program and shall make a consequence of such violence, particularly toward educating the public on its social impact. We might ask, what are the rights of the victims, or what are the rights of the victims of violence against women and their children? So in addition, under this act or the existing laws, the victims of violence against women and their children are the following. First, to be treated with respect and dignity. Second, to avail of legal assistance from the PAO of DOJ or Department of Justice or any public legal assistance office. And next, to be entitled to support service from the DSWD and the LGU or the local government unit. And next, to be entitled to legal remedies. And last, to be informed with the rights and services in our country. So that would be all about the act defining the violence against women and their children. So if you have any clarification or questions regarding our topic, please feel free to ask through our Facebook account. So that would be all. Thank you for watching, thank you for listening, and may God bless us all.